And then Amanda, if you want to go ahead and start it off.
Awesome. Thanks so much, Anthony. Well, good afternoon, everyone, and thanks so much for joining us. As Anthony shared, my name is Amanda Wicker, and I am with the City of Corona's Office of Economic Development, and want to welcome you and thank you for joining us. I think today's topic is really important. It's something that's really hard to keep track of in California, I think especially. So I know today's call is going to be really informative for you. Just really quickly before we jump in, I just wanted to highlight a couple initiatives and upcoming digital events that the City of Corona is hosting in partnership with some of our great resource partners, such as the Corona Chamber of Commerce. Really quickly, just wanted to point out, we just launched an initiative called Live Work Corona. And this whole initiative is really geared at trying to better connect Corona companies with Corona job seekers, our resident community. And so one of the ways that we're doing that is we're hosting this digital engagement series, and there's going to be some sessions that are geared towards job seekers, some sessions that are geared towards companies and ways that they can better utilize online tools, especially through Google and Constant Contact, in order to make their work environment more engaging, allow more at-home work opportunities, things of that nature. So as I mentioned, we're partnering with our Chamber of Commerce on this, as well as Grow with Google and Constant Contact. Our first webinars kick off next week. We have our first one, Get Your Local Business on Google Search and Maps, occurring next Tuesday at 2 p.m. These events are totally free to participate in. And we invite you to visit our website, coronaca.gov, for more information, as well as where you can register for more information. And then lastly, I wanted to let you know about a virtual meeting that we're going to be hosting in relation to our downtown revitalization plan. If you're not familiar, we've been under a process to try to revitalize Corona's downtown. And so we've been going through a lot of visioning exercises and community meetings. We've had a few in person over the past couple of months, and we're going to provide an opportunity for people to engage digitally through a Zoom meeting if that's their preference. So that's going to be occurring next Thursday, February 24th from 5 to 6:30 p.m. Again, that's via Zoom, absolutely free to participate. And there's going to be an update in terms of where we're at in the process. And again, an opportunity for people to express themselves, voice concerns, share ideas, hopes, desires for revitalized downtown Corona. So definitely want to encourage you to RSVP for that, and definitely reach out to us. You can send us an email if you'd like to attend, downtowncorona@coronaca.gov. And with that, I'll turn that back over to you, Anthony. Thank you.
Thank you so much, Amanda. And I want to thank the City of Corona for always partnering with us to help put on great programs like this one and some of the other ones that I just want to touch on very quickly. And that is on February 28th at 8 a.m. We will be hosting a special seminar for the restaurant community. The focus will be on how to best utilize social media to help promote your restaurant and expand your online presence. So if you have any restaurants that you frequent or any restaurants in mind that you would love to, they're not doing so well social media wise, and you would really love to help have them promote their business a little bit more online, send them to this seminar. It's going to be really great. We have two incredible speakers lined up, so make sure you reserve your spot now. You can learn more at the bit.ly on your screen. And then also, we have Corona Night with the Angels. It is returning this March. It is a preseason game. You can join all your friends from Corona as the Angels take on the Dodgers in another freeway series battle. So tickets are as low as $35, so grab them now and they will sell out fast. And lastly, I wanted to touch on, since we do have Good Morning Corona tomorrow featuring Sheriff Bianco, we are already prepping for our March date, which is March 17th. Supervisor Spiegel will be joining us for the State of the County address. This is an excellent networking opportunity and a great chance for you to learn what is going on in the county firsthand. So sponsorships and exhibitor tables are available now. See the link below for more information, or contact Stephanie here at the chamber, and she can definitely provide you with any questions that you may have, or any additional information. So with that said, I want to go ahead and introduce our speaker and jump right into today's program. Mr. Kauf represents employers of all sizes in matters of workplace privacy, data security, unfair competition, and trade secret theft, and corporate espionage, both on the plaintiff and defense side. He also represents employers in other areas of employment law, including wage and hour, harassment and discrimination actions in state and federal court, in private arbitration, and before government agencies. He is very passionate about helping employers do the right thing and be fair to their employees. He really knows his stuff, and we are really honored to have him join us today. So without further ado, please welcome Usama Kauf.
Thank you, Anthony, and thank you to the Corona Chamber of Commerce for this invitation. It's always my pleasure to come and join you guys every year. I've been doing it for a number of years. Although I apologize for this not being in person, mostly because of me, as I have upcoming travel on vacation on Monday with family, and I wanted to make sure that nothing is resulting in last-minute cancellations. So let's jump right in. I'm going to share my screen. And we're going to talk about the big changes and the road ahead of us in 2022 and beyond for employers in California. These are the big picture issues, items that employers are faced with. We'll talk about the status of COVID-19 related regulations and guidance that is out there that is changing every week. We'll talk about unique issues that have arisen in the last couple of years related to remote work that employers are going to be facing as the nature of work changes. We'll talk about the Private Attorney General Act and the state of litigation when it comes to that issue, including a big case before the U.S. Supreme Court this term. We'll talk about privacy law changes for employers that will kick in by the end of the year. As well as a couple of new laws that have been passed that will affect employers this year, and a couple of very significant court decisions as well. So first, COVID-19 in the workplace obviously has resulted in a whole lot of regulations. First, just the big ticket items. As you all know, the federal OSHA vaccine mandate was struck down by the U.S. Supreme Court on January 13th. So that is out. A federal judge had also struck, at least enjoined temporarily, the vaccine mandate for employees of federal contractors. So that is currently being litigated. And then the final piece is the vaccine mandate for healthcare employees. That is also that was allowed to stay by the U.S. Supreme Court, but it continues to be challenged in various locations. The Cal OSHA emergency temporary standard was readopted for a second time. And this readoption was effective January 14th, and it goes through April 14th. And as a result of the changes, several of the FAQs that Cal OSHA had put out have been updated. So if you haven't taken a look at the Cal OSHA website recently, I recommend that you do so, as there are certainly a number of changes to those FAQs. And then those were recently updated about 2 weeks ago by Cal OSHA. The California Department of Public Health has also updated the definition, the standards for quarantine and isolation periods. Generally, this was reduced to 5-day isolation and quarantine periods with testing, and then a masking requirement for healthcare professionals, healthcare personnel after that within a certain period. So that was in the past, it was a 10-day period for isolation and quarantine before someone is allowed back into the workplace. Now it's 5 days. And if they don't have any symptoms, they can come back. They just have to be masked for a certain amount of time. And then, of course, it's different for healthcare employers. The fourth item here is that As you all know, the statewide mask mandate has been lifted for fully vaccinated individuals indoors, with certain exceptions. The definition of fully vaccinated has not changed. It still doesn't include people who are have received the booster. So that may change soon, but it currently has not changed, but the mandate has been lifted. However, pay attention to local mask mandates if you have employees or operations in other jurisdictions, whether counties or cities or states that have their own requirements. For example, LA County or City of Pasadena, if you have employees over there. Just remember that there are different mask mandates, and the more restrictive one is the one that has to be followed. We expect that later this year, or at some point, Cal OSHA is going to work on a permanent, instead of a temporary one that is currently in place, going to work on a permanent standard related to COVID-19. So that is going to be there to stay once it is passed, and all employers will have to respond and implement the appropriate policies. And then hot off the press, most recent change is the renewal of the COVID-19 supplemental paid sick leave. So let's talk about that. And this is just a very, very recent change that just got passed. The first thing to know is that this affects employers with more than 25 employees. If you have 26 or more employees, is another way of saying this, then the law applies. If you have less than that, then the law doesn't apply. However, pay attention to any local, county or city supplemental paid sick leave or paid sick leave that might apply. When is the law effective? Well, it's effective this Saturday, February 19th, and it will remain in effect until the end of September of this year, unless it is extended again by the legislature and approved by the governor. It is, however, retroactive to January 1st of this year, meaning that if you've had employees in the last 6 weeks who have taken paid sick leave, and that paid sick leave was taken out of their vacation, their PTO, or taken out of their regular paid sick leave, then you, unless if you want to also provide them an additional up to 80 hours of supplemental paid sick leave beyond this, you can retroactively go back and change and also issue a corrected pay stub, or record this in their next pay stub, that the time that they had already been paid for and taken that was previously earlier this year accounted for as vacation or PTO or other paid sick leave is moving to this new bucket that is retroactive for supplemental paid sick leave under this law. And if you have employees who have taken unpaid leave and weren't paid for the time, and they would have qualified for it, then you have to go back and pay them if they request that. And that also includes a requirement that you notify employees of this new law and their rights under this law to request this leave retroactively to the beginning of the year if they haven't already been paid for it. How much leave is required is a little different from the supplemental paid sick leave that we've seen before. So in the past, it was just one bucket of 80 hours for certain eligibility reasons related to COVID-19. Now we have actually two buckets. The first bucket is 40 hours, and the employee is eligible for taking up to 40 hours of paid sick leave under this law for COVID-19 qualifying reasons. Leave must be provided if the employee is unable to work or telework, if they're unable to work at home or work, for one of the following reasons. The first reason is if the employee is subject to a quarantine or isolation period related to COVID-19, as defined in an order of any state, local, any other kind of federal, state, or local agency or public health officer who has jurisdiction over the workplace. So if they're required to quarantine or isolate based on an order or guidance from any state agency, state or federal agency. The second reason for which they can get this up to 40 hours of paid sick leave is if the employee has been advised by a doctor to isolate, or a healthcare provider to isolate or quarantine due to COVID-19. The third reason is if the employee is attending an appointment for themselves or a family member to get the vaccine or a vaccine booster against COVID-19. And then associated with that is another reason, which is if they are experiencing symptoms because of getting a vaccine shot or the booster for COVID-19, then they can take this time off. Of course, assuming that they are unable to work or telework, work remotely. Another reason they can take up to 40 hours of in this first bucket is if the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. If the employee is caring for a family member who is subject to an order or guidance, who has been advised to isolate. And then, of course, if the employee is caring for a child whose school or place of care is closed or otherwise unavailable for reasons related to COVID-19 on the premises. All of these are reasons for which they can qualify for up to 40 hours in this first bucket. However, one interesting note I want to raise here is that there is actually one limitation on two of those reasons. So two of the reasons I mentioned are if you're taking the vaccine or you're making an appointment to go get the vaccine for COVID or the booster shot, or if you're experiencing symptoms resulting from the vaccine or booster. If either of those two reasons apply, then the employer may actually limit the total leave to 3 days or 24 hours. And then if the employee needs more leave related to either of those two reasons, like if they're still experiencing symptoms or got sick because of the symptoms of the vaccine or the booster, then the employer may require that the employee provide verification from a healthcare provider that the employee or their family member is continuing to experience those symptoms related to getting the vaccine or the booster shot. Otherwise, if it's related to symptoms from the vaccine or booster, then they're limited to 24 hours unless the employer requests that they provide documentation for anything above the 24 hours. The second bucket for which employees may be eligible for paid sick leave under this new law is if they get a positive test. So if the employee has a positive test or is caring for someone who has a positive test, then this would be the bucket. So if the employee tests positive or a family member for whom the employee is providing care tests positive, they can submit this request and take up to 40 hours. So in the first instance, if the employee tested positive, the employer may require the employee to submit a diagnostic test or to submit to a diagnostic test on or after the 5th day after the initial test was taken, and then provide documentation of those results. This law specifically states that the employer shall make a test, such a test available at no cost to the employee. So if the employee is tested positive, then you can require them to submit to a diagnostic test on or after the 5th day after their initial test, and that test would have to be paid for by the employer. The next question to address is how much is the rate of pay? So if you recall or have been looking at the rate of pay under the prior supplemental paid sick leave last year, there were a number of methodologies in that law, and that law said you have to use whichever one results in the highest rate of pay. Well, this is actually a little different now with this new COVID-19 supplemental paid sick leave that's effective this year. But it's a little easier because the law says that the rate of pay that you have to use for supplemental paid sick leave is the same regular rate of pay that you use for purposes of calculating the rate of pay for regular paid sick leave. The paid sick leave that's been on the books in California for several years, that's the up to 3 days or 24 hours of paid sick leave that all employees get for certain reasons. If you're not familiar with the calculation method for regular paid sick leave, it's one of two methods, and it's for non-exempt employees. Hourly non-exempt employees would have to get paid their supplemental paid sick leave using one of two methods. The first measures the regular rate of pay within a particular work week. The second measures the regular rate of pay based on the full pay periods within the last 90 days. And so make sure you pay attention to the particular rate of pay method and calculation. This only really makes a difference if you're talking about an hourly employee who receives, in addition to their hourly pay at any time in the year, non-discretionary bonuses or commissions or other types of incentive pay or piece rate pay in addition to their hourly pay. If the hourly non-exempt employee does not receive any of those and just simply receives hourly pay and they don't have any other kind of compensation, they don't have to worry about it because their rate of pay is essentially their hourly rate, their regular standard hourly rate. So this only applies, the need to calculate what the regular rate is if the wages of the hourly employee fluctuate because they get paid certain non-discretionary bonuses or commissions or other type of incentive, non-discretionary incentive pay, because that would also affect the overtime rate. So if you pay them overtime, your overtime is not just simply a time and a half, their base hourly rate. You have to account for commissions and non-discretionary bonuses and these other things in the same way that you have to for purposes of paying them for sick leave. The next issue to address here in this law is that unlike in the past under the supplemental paid sick leave last year, with the one that is effective this year, employers cannot require employees to first use and exhaust supplemental paid sick leave during a period in which the employee is entitled to exclusion pay. And we'll talk about exclusion pay in a second, but it's pay that they're entitled to under the Cal-OSHA emergency transportation, emergency temporary standard, not transportation, emergency temporary standard, ETS. And finally, the last point here is, unfortunately, there is no dollar for dollar reimbursement for employers like there was under the federal FFCRA for providing this paid sick leave. However, there are some tax credits on the horizon here that have been negotiated between the governor and the legislative leaders in Sacramento as part of the agreement to renew supplemental paid sick leave. It didn't end up in this particular statute, but there are some tax credits that are generally going to be applied, not directly because of payment of SPSL, but for example, the deal that was struck in Sacramento includes restoring net operating loss deductions for corporate and individual taxpayers with business income of 1 million or more, which had been paused for tax years 2020, 2021, and 2022, and extended by 3 years. So that's one thing. The second is that the state is going to lift the $5 million limit on several other business tax credits, including for research and development for those same tax years, those 3 tax years. Obviously not all businesses are eligible for these tax credits, but there are more tax credits that are going to be available to hopefully, or at least for some businesses, deflect some of these additional costs that are being incurred here. Just a last thing on supplemental paid sick leave, since it takes effect this Saturday, make sure that you have implemented the appropriate notice. There's the notice that you have to give to the employees about their rights under this new law, and having the appropriate forms, the appropriate documents. So, all of that needs to be done and needs to be done very quickly, as well as if you have had employees who took time off since the beginning of the year, but were not paid for it, and it was because of a COVID-related qualifying reason, then if they request it and they have a right to request it, you got to go back and pay them and provide accurate information on the next pay stub that reflects the payment for that. And there are also other potential corrections you may have to go back and make for anyone who was already paid for it and taken it since the beginning of this year. With respect to other key Cal-OSHA requirements to consider, one of them is that you have to establish and implement and maintain an effective written COVID-19 prevention program. And so this is part of the requirements that are currently in effect. A WCPP, written COVID-19 prevention program, is a program that you have to have in place that includes training, that includes policies, forms, procedures, etc., and that you have to actually implement. Similar to similar, but not exactly the same as an illness and injury prevention plan, the IIPP that has been required under Cal OSHA standards for a long time. So if you don't have that, obviously you need to have it. But here, you now have to have a written COVID-19 prevention program and actually implement it. It's a packet of materials and forms and things along those lines. You also have to provide training and instruction to employees on how COVID-19 is spread, infection prevention techniques, and information regarding COVID-19 related benefits that affected employees may be entitled to under applicable federal, state, or local laws. Training and instruction and information to employees really can go a long way in hopefully preventing unnecessary litigation. My firm and I have seen a lot of litigation in the last couple of years related to employees expressing concerns about COVID-19. And then at some point after that, suffering an adverse employment action such as termination or demotion or suspension. The claim is retaliation because they complained in some way, expressed concerns about the company's efforts to comply with COVID-19 requirements and standards and to protect the workplace. So transparency and communication is key to preventing those kinds of claims to make sure that you alleviate paranoia and concerns. A lot of this is really based on misinformation and fear that sometimes is rational, sometimes is not. And so it's important to communicate effectively and to train employees and to really show them what you're doing, because if they don't know what you're doing to protect the workplace and you haven't really laid it out for them in writing and in the very clearly, then one can understand why they don't know what's going on and will allow for the potential to assert claims when they raise these concerns and then they feel nothing was done about them and then suddenly they're getting fired. So that's one thing I recommend, is that you do that proactively and you emphasize transparency and communication. There are notification requirements that need to be complied with, and you got to continue to comply with them in the event of exposure in the workplace. There is a requirement to conduct some contact tracing, figure out who was in close contact with the affected individual, with the individual who tested positive in the workplace. Make sure you communicate with those individuals, get them to get tested, pay for the testing, and follow the appropriate standards. But there is notification that needs to go out to those individuals. Then there's also notification that has to go out to all the employees, not just the individuals who are within the close proximity, which close contact, which is within 6 feet for more than 15 minutes. That would be close contact. But beyond those individuals that are within close proximity of the affected individual, there is notice that we need to go out to the entire staff that would tell them that there was an exposure in the workplace. All individuals who were within close contact have already been communicated with and are taking appropriate measures to get tested and take other precautions. That you tell them that you've taken appropriate cleaning measures to clean and disinfect the workplace, and you remind them of the standards that are in place for preventing exposure in the workplace. So that's all part of the notification requirements. Then there's also exclusion pay. So when do workers need to be paid exclusion pay if they're exposed to COVID-19? When workers are required to be excluded from work due to work-related COVID-19 exposure, they have to be paid exclusion pay. There are some exceptions. For example, if the worker can work from home, or they are receiving disability pay or workers' comp temporary disability payments, then they wouldn't qualify for exclusion pay. But exclusion pay is required under the Cal OSHA standards. And so you got to look at making sure you complied with that pay. How long does it continue? Well, typically, at least 5, maybe 10 days, depending on the circumstances. They're also testing obligations, including paying, under what circumstances do you have to pay for testing? That also needs to be looked at. What is required if a worker was exposed to COVID-19, but testing is not available? So we've seen a shortage in tests or inability to get testing in some cases. So what happens in that circumstance if the worker was exposed to COVID-19, but tests are not available? What do you do? So that's also a question to address. The answer is it depends on whether they are fully vaccinated or not. If they're not fully vaccinated, then the rule is they have to continue to quarantine for at least 10 days. If they're fully vaccinated, then if they can't be tested on or by day 5 after exposure, then they can be brought back into the workplace, but they have to wear a face covering and maintain social distancing. Outbreak obligations. So if you have 3 or more COVID-19 exposures to employees in the workplace, that's one type of set of requirements. And if you have 20 or more, that's a whole nother set of requirements. So that's something to consider. There are also rules specific to employer provided housing. What sort of standards do you have to implement there, as well as transportation that is provided by employers. It is very important that if the employer is adopting testing or vaccination requirement or policy, that you look at this issue of reasonable accommodation. There's a lot more litigation involving this now. So if an employer requires employees to test or be vaccinated, the employer must allow for exemption requests based on medical condition, disability, or sincerely held religious belief, practice, or observance. You got to have a written policy that includes the accommodation request procedure, so employees know how do they request an accommodation. They need to fill out a form, and it really it streamlines the process. You got to have a process for handling the requests. You have to engage in the interactive process. It's a two-way street. The employee also has to participate and has to provide the information that is requested. They can't just simply be obstinate and not provide you the information that you're legally allowed to ask for in these circumstances, depending on the issue. So if, as part of the interactive process, you need more information, you need some documentation for some things, the employee has to cooperate with that in order for you to do your job of considering what accommodation is being provided. So at the end of the day, you have to consider the accommodations that are being asked. Sometimes you grant, sometimes you deny, depending on whether it's reasonable or not. So consider all the different possibilities and whether those will pose a threat to the safety of others in the workplace. If there is a direct threat to the safety of others in the workplace, it's probably okay to not allow that request, but then consider whether there's a lesser accommodation that can be provided that is still reasonable. When it comes to undue hardship, that is typically the most common defense to failure to accommodate claims. However, that undue hardship is a very high standard, and typically it depends on whether the requested accommodation is going to cause you financial collapse. It is beyond just financial difficulty and beyond just costing a lot. There's a question of what does it mean for it to be really undue hardship, and it's beyond just simply it's going to hurt for a little bit financially. So it's very important to document this process. And finally, I want to emphasize how critical it is to train your supervisors at all levels, and don't assume that the employees or the supervisors are going to go to HR with everything. You can have policies, you can have reminders that tells people that if you have any issue related to accommodation, you need to come to HR. You need to come to HR. You need to involve HR. As much as you still remind people and put that in writing, you'd be surprised how many decisions or discussions are had between the employee and their direct supervisor without involving HR and without getting HR involved. I mean, I had a situation once where the supervisor essentially didn't involve HR with anything. The employee ended up losing their job. The employee sued, and I pulled up the complaint, downloaded it from the core website because I saw the company got sued. And that was the first time that the owners of the company and HR knew that the employee lost their job, and it was like a month after that happened. And so they were surprised. Their answer was, "Wait, hold on a second. We thought he was on an approved medical leave of absence, and he was." But the supervisor had essentially told the employee, when the employee attempted to provide a doctor's note with restrictions, that I can't have you here unless if you're 100% healthy, which is not it's a discriminatory statement to make if it was made in that verbatim as that, and didn't provide the doctor's note to the HR, no other discussion of accommodations, etc. And then the employee came back 3 weeks later with a full release from his doctor, and the supervisor did not tell HR, did not involve HR, and they just simply told the worker, I can't, I'm sorry, I filled your position already. And so that's when the worker sued, because their position was filled, even though they had a right to be reinstated to their position under the law in that particular circumstance. So that's a lesson to all employers, that your supervisors who don't understand the law or don't understand the implications of what they say to employees in these circumstances and how they can get the company sued really can get you in trouble.
Usama, I do believe that we lost, we cannot hear you. Usama, can you hear us?
Can you hear me now?
Yes.
Okay.
Awesome.
Where did I leave off? Sorry, guys. I don't know what happened to my headset.
It was about 2 minutes ago, so I do believe last slide, right before, about right there.
Okay. So I apologize about that. Privacy concerns when it comes to COVID-19 include, where do you store this information? So if you've been collecting information about employee vaccination status, about testing, symptoms, etc., it's important that you store it in a separate medical file, not in the personnel file. You only keep it for legitimate reasons, and you delete it once you no longer need it. And also make sure you restrict access to those who need the information. One of the things in this area that have come up in the last couple of years that will continue to be an issue for employers is, what about employee privacy when you have to disclose certain things to other employees? And the answer is, generally, you're not allowed to disclose medical information of employees without the employee's specific written consent. However, there are exceptions. One of them is if you have to comply with a law that essentially requires you to disclose the identity of the person. When it comes to notifying employees of an exposure in the workplace, You should not be revealing the identity of the individual employee affected, and don't mention their name. If the other employees just end up inevitably finding out who it is by process of elimination because they know who was in the office on what day, and you're basically asking them, who are you around? They will know, right? But you didn't disclose it. You were just simply doing your contact tracing and notification and complying with the notification requirements that are required by law. When it comes to dealing with remote work, as many of our of the employees moving into the future are going to be remote, a lot of businesses are going to a hybrid type of environment where people are working at home parts of the week, and some are going to full remote work because they've learned through the pandemic that it can be done, and they can actually be quite efficient and effective. So I want to highlight some of the key issues that employers are facing to address and to consider this year with policies and procedures. The answer to a lot of these issues is very often having a written, having an actual written work from home policy and agreement where employees specifically sign off and agree on policies that apply when they are working at home remotely. One of the issues is recording their time. How do you make sure that the people working at home are recording their time? What sort of procedures have you put in place for that to happen? How do you make sure that they work their scheduled hours and they're actually being productive? What about the meal and rest breaks? They're on their own. They're at home. They can do whatever they want for the most part. How do you make sure that they are taking their breaks? Are you looking at their time records for that? Travel time becomes interesting because if the employee is now essentially remotely working at home the entire time, then there is no commute, right? And that means that if they leave the workplace, which is their home, to go to engage in some work activity, we're talking about non-exempt employees, to engage in some work activity such as visit a customer, such as actually going into the company office on a day that they are not scheduled to be in the office because they're just working remotely at home. Well, that's not, if the time spent going to the office is not part of any regular commute, then it potentially has to be paid as paid time because it is not part of a standard commute to the office. We also are seeing a lot of litigation that will continue this year and beyond related to misclassification of outside sales employees. Under California law, in order to be exempt from overtime and other wage and hour rules, an outside salesperson has to spend more than 50% of their time away from the home and any company office or location engaged in sales or sales related activities. So if the outside sales employee who before the pandemic was out there, meeting with everybody, going to presentations, doing pitches with clients, etc., and schmoozing clients and whining and dining on clients, and then suddenly they've been sitting behind a desk at their home office, Zooming with everybody, then are they now misclassified? That is the subject of a lot of litigation. So make sure you consult a lawyer on that issue. Another issue to consider is perhaps you can take advantage of other more favorable state laws because if the employee is in another state, that state law applies to the work that they are there if they become an employee in the other state, right? So we're not talking about a California employee who goes on a trip somewhere else. California law is still going to apply to them. But we're talking about hiring people in other states entirely so that they're just the employee is 100% in the other state. So California law doesn't apply. The next issue to consider is reimbursement of business expenses. This is very important. You got to address this issue because there's a lot of litigation related to the expenses that employees incur when working at home and what expenses you need to pay for, what expenses you don't need to pay for. For example, you probably don't need to pay a portion of their mortgage or rent, but you probably need to pay a portion of their internet bill because of the use of the internet at home. Posting requirements is interesting because if now your workforce is all remote, you don't. How do you post to them policies that need to be posted in a physical workplace? Those will need, can certainly be communicated electronically. And finally, cybersecurity risks is a big issue to highlight here. We can go on for an hour just on that issue alone. So I'm going to go on to the next topic, and that is PAGA. PAGA is the Private Attorney General Act that was passed in 2004. It is a law that is different than class actions. A PAGA claim allows employees to sue on behalf of the state of California to enforce the labor code, to seek penalties for all violations of the labor code, not just for the employee, but all other employees. And it is different than a class action, because in a class action, you are seeking unpaid wages as well as penalties. And you're not representing the state, you're representing all other employees. And there is a requirement in class actions that the claims of the plaintiff employee have to be typical to the class or similar to the class, meaning you're only suing on behalf of other employees in a class action that are affected by the same policy or procedure. However, under PAGA, you sue on behalf of the state and you sue for all violations, even if none of those violations happen to you, as long as the plaintiff employee has suffered at least one violation of any section of the labor code. So that's how it's different. It has unfortunately resulted in the ability of plaintiffs to bypass arbitration agreements that have enforceable class action waivers, because the California Supreme Court has ruled that a PAGA claim cannot be compelled to arbitration or cannot be subject to an arbitration agreement. And therefore, the PAGA claim would continue in court while the employee's individual claims would have to proceed in arbitration, resulting in employers still having to deal with these large cases where the potential penalties are very, very significant. You underpay an employee $5 and suddenly you're facing tens of thousands of dollars in potential penalties under the PAGA claim, because there are many derivative claims, and every little violation means you've also violated 10 other laws that you didn't know about just by virtue of the one specific violation. So there is a lot of potential for abuse, and especially smaller employers going out of business or having to pay an exorbitant amount of money to settle these claims, when an arbitration agreement could have saved all of that by making sure that the employee is only litigating their own individual claim and have waived any right to sue for other employee violations. So PAGA is currently before the US Supreme Court. The US Supreme Court is reviewing in the Viking River case that I believe is going to be heard by the court, oral arguments in April, and should be decided by the summer, by the end of the current US Supreme Court term. And so if that is decided in favor of the employers, it would mean that employers can avoid PAGA claims altogether by having arbitration agreements that are valid and enforceable with employees that would cover wage and hour claims, so that the employee would only proceed in arbitration against the employer on their own individual claims and not on the claims of any other employee. And there are also some there's a ballot measure that could potentially be on the next election or the one after that, that would repeal or replace PAGA with something else. Privacy law issues on the horizon this year for employers. Employers of a certain size are going to have to address CCPA compliance by the end of this year, if they haven't already addressed it. So the California Consumer Privacy Act is a consumer law that actually affects employee data that took effect January 1st, 2020. It applies to for-profit businesses only that do business in the state of California and that qualify based on any one of these three criteria. You don't have to have all three, but if you have one of those criteria or you satisfy one of them, then the CCPA applies to your business. Annual gross revenue of over 25 million, annually collecting or receiving personal information of 50,000 or more California residents, household or devices, or if you derive more than half of your annual revenue from selling consumer personal information. And so if you are a small business or a nonprofit then you don't have to worry about this law. If you are in the category of businesses that are covered, all of the requirements related to employee data have been postponed, fortunately, until 2023, except for two. So effective 2 years ago, employers that are covered by the CCPA have had to provide a notice to all of employees and job applicants related to the categories of information, describing the categories of information collected about or from the individuals, and then the ways in which you're using the information. And then the second requirement that's still applied that has not been postponed is a requirement to implement appropriate security measures to secure the information of the employees and job applicants. However, starting in 2023, because of Prop 24 in the last general election, all of those requirements that were postponed are coming back. And that puts on the same level playing field all employees with consumers, with customers, with individuals that are California residents. So starting in 2023, employees are going to have a lot of rights under the CCPA that employers will need to get up to speed on. There is a lot of work to be done on the CCPA front in the next 10 and a half months. So if you're in this boat, you haven't done anything related to CCPA for 2023, it takes probably about 6 months to get ready. So you got to get started sooner than later. And there's really a whole lot of work ahead of you, including completing a data inventory, including negotiating and entering into updated data processing agreements with your vendors, including implementing a process for employees to submit all sorts of consumer requests starting in 2023, updating the notices that are provided to employees, having a privacy policy, a whole lot more that I can go on and on. But I just wanted to highlight this as something to that if you're in this boat as a covered employer, then there's action to be done over the next 10 and a half months that needs immediate attention. I'm going to cover a few laws real quick that have taken effect. One is the most recent, which is on the federal level. It's the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act that actually garnered bipartisan support in both the Senate and the U.S. House of Representatives. So this law prohibits employers from enforcing arbitration agreements for disputes involving or claims involving sexual harassment or sexual assault. It allows employees to sue in court for these claims individually or on behalf of a class, and it applies to existing arbitration agreements and claims. So arbitration agreements are an effective way to make sure to limit an employer's exposure on a class action basis, really when it comes to wage and hour claims. So class action waiver in an arbitration agreement, the courts have held that is generally valid and enforceable, subject to certain exceptions. So assuming it's a valid and enforceable class action waiver, an arbitration agreement is a powerful tool to avoid having to face class actions in court because the employees will have to proceed on their own individual claims in arbitration. When it comes to sexual harassment and sexual assault, however, now those are completely out. Now you can still have arbitration agreements, but when you want to go ahead and enforce them, you won't be able to enforce them against claims that are sexual harassment or sexual assault. So it's a good idea to revisit and review your current arbitration agreement. If you don't have an arbitration agreement, I highly recommend you adopt one with employees. There are a lot of pros and cons. There are some disadvantages. So consult a lawyer on the drawbacks as well as the benefits of an arbitration agreement in light of this new law. The next is the California Senate Bill 331, which is the Silence No More Act extension. This is a follow-up to a law that was passed in the prior year that banned non-disclosure agreements and settlement agreements for claims of sex discrimination or harassment. So this new law does three things. Number one, it expands the prohibition of confidentiality provisions in agreements for claims of in agreements that were entered on or after January 1st for discrimination, harassment, or retaliation beyond sex. So the prior law just limited to sex discrimination and harassment. Now It's it's discrimination, harassment, or retaliation based on any protected category, not just sex. The second change is this prohibits non-disparagement agreements that are required as a condition of employment that prevent employees from disclosing information about unlawful acts in the workplace. And then finally, it also applies to severance agreements containing any provision that would restrict an employee from discussing unlawful acts that took place in the workplace. Any non-disparagement agreement would have to have certain language, and it's this language here that says, nothing in this agreement prevents you from disclosing or discussing any information about unlawful activity that took place in the workplace or any discrimination that the employee has reason to believe is unlawful. It is effective January 1st, so it's going to nullify or make void any provision of an agreement that is entered on or after January 1st of this year. It doesn't affect agreements that were entered into before that. Some good news is that you can still insist on clauses that prevent disclosure of the amount of any settlement money that was paid, as opposed to the underlying facts in these cases. So that's a pretty important carve out. The next bill I want to talk about is the clarification and expansion of CFRA, that is the California Family Rights Act law. It is the state equivalent of FMLA, the Family Medical Leave Act, which is under federal law. Last year, if you recall, the California Family Rights Act was amended to drop the threshold for application of the law to employers from 50 employees down to 5. So now even small employers with just 5 employees have to follow the CFRA. And the CFRA provides up to 12 weeks of unpaid leave with a guarantee of reinstatement to the same or comparable position and with the same or comparable pay for an employee who has a serious health condition or is caring for a family member with a serious health condition. So 5 or more employees, you got to follow this law. You got to have a policy for it, forms related to what information you can ask so that the healthcare provider can certify the reasons for the leave. You got to make sure you follow the appropriate procedure. The law, as last year, also expanded the definition of family member to include grandparents, grandchildren, siblings, which were not previously part of the law. This latest change that became effective this year expands the definition even further to include parents-in-law. That's really the only change this year, but I highlight it because if you hadn't heard about the change last year, it's important that you address it now because it's a very significant change. Down the road, we think we would expect that there's going to be discussions in Sacramento about expanding paid sick days, expanding other definitions under the CFRA, maybe cannabis accommodation, bereavement leave. These are all things that are being discussed. Nothing yet concrete on the horizon on those, but just things to look out for, by the end of this year that may change the law by next year. Lastly, in the last couple of minutes I want to look at significant court decisions, really 2 of them that took place this year. There are others to cover, but these are ones that I think are probably the most crucial for the audience here. First is Farah versus Lowe's Hollywood Hotel. In this case, the real issue was what is the rate of pay at which an employer is required to pay for the meal and rest break premiums. So if a meal or rest break were not provided appropriately to the employee, for example, if the employee was required to work through lunch or was prevented from being able to take a lunch break on time starting before the end of the 5th hour, something got in the way. For example, a customer was there was anyone else that could come and cover the employee, so the employee felt like they had to not take the break. That would be a violation, right? So in that case, the employer would owe the employee 1 hour of pay. For hourly employees that only get paid an hourly rate and they don't get any commissions, any bonuses, etc., no problem. You just pay them the 1 hour at their regular standard hourly rate. For non-exempt employees who are also paid commissions or who are paid non-discretionary bonuses, other type of incentive pay, all of that has to be accounted for based on this new case where the court said that the regular rate of pay is going to be the same regular rate of pay for purposes that you would calculate for purposes of overtime. And this decision applies retroactively. So if you had paid a meal period premium at the standard hourly rate for the employee, their base hourly rate, but the employee was receiving commissions or non-discretionary bonuses, that means there's a potential underpayment to consider there. So takeaway is you got to revisit and looking at to making sure that meal period premiums and rest period premiums are paid at the appropriate regular rate of compensation for the employee to the extent that the non-exempt employee receives commissions or non-discretionary bonuses. And the last case to look at is Donahue. Donahue had a couple of different issues. It's also about wage and hour meal period violations. The first is rounding of time punches. Is that legal? And not the rounding for the entire time periods from the punch in at the beginning of the day and then punch out at the end of the day. I'm talking about rounding just for those 30 minutes in the middle. If they punch out and then they punch back in 29 minutes later, can you lawfully round so the time records show they took a 30-minute? Is that lawful? And by the way, the answer is no, it's not. So no rounding at all for the punch for punching out and punching back in for lunch. The second issue in the case is if the time records show that an employee missed a meal break or that they took a short meal break or they started the meal break too late, does that mean that you're already in violation of the law? And the court found that on the first issue, like I said, rounding is illegal when it comes to just the lunch period. Of course, we all know that rounding can be lawful when it comes to your time records up to a 15-minute increment, 6-minute increment, etc. You can round as long as it's a neutral policy and you have audited your records regularly to confirm that it more often than not favors the employee, rounds in favor of the employee than in favor of the employer. But generally speaking, rounding is a bad idea. I highly recommend against it. If you want to talk to me about it offline, I'm happy to do that. But 9 out of 10 times, it just gets you sued. Even if the policy is lawful at the end of the day, it's going to cost you too much in litigation and settlement expenses because every plaintiff's lawyer that sees a rounding policy will assume that it's not compliant and will sue only to find out later whether it is or not. But they're never going to find out in most cases because the employers are just going to settle and pay a bunch of money to avoid the expense of litigation. So rounding is just a bad business practice to have. I highly recommend against it if you have it, even if it is at the end of the day actually lawful. The second issue here is what about time records that show a missed meal period or a short meal period or a late meal period? And the court said that creates a rebuttable presumption that there has been a violation, which shifts the burden back to the employee, which shifts the burden back to the employer to prove that the employee knowingly or voluntarily chose not to take the meal period. So if your meal period, if your time records show that an employee missed a meal period, that's there's a presumption that there has been a violation. And you have to prove that the employee on that day voluntarily chose not to take it and wasn't under some pressure because of the work environment or a manager told him not to take it or so on. One way the court said that you can overcome that presumption is if you have attestation language in your timekeeping system that flags before an employee clocks out, for example, that flags for them, hey, you didn't take lunch today. Did you actually take it? And the answer is yes, they correct the records. If the answer is no, will the employee attest and certify that this was voluntary, that they chose to do this, or they can answer and confirm that no, actually there was some pressure, a deadline, something happened that prevented them from taking it. So if you have attestation language where the employee certifies that they voluntarily chose not to take the break that day, that overcomes the presumption, and then the burden shifts back to the employee to prove that that was inaccurate in some way and that they actually were not allowed to take the break, and that they basically lied when they submitted their attestation. That's a very good news for employers because it means good takeaway here is to make sure that you have looked at your timekeeping system and adopted the appropriate attestation language, because that will help you a lot in defending against failure to provide meal break claims. All right, we have come to the end of the presentation. There's a lot of issues here. Here's my contact information. Feel free to reach out to me. I have the wrong date here on this slide, but yeah, feel free to reach out to me if you have any questions. I'd be happy to provide you with more information. But thank you to the Corona Chamber of Commerce for the invitation. Thank you all for being here, and turn it back to you, Anthony.
Thank you so much, Usama. Before we close out the meeting, does anyone have any questions at all?
I had put mine in the chat.
All right, 1 second. So 3 or more exposures within what time frame?
This is referring to outbreaks. What classifies it as an outbreak? Is it within 2 weeks, a month? What is it?
I don't know the answer off the top, but it can be answered very quickly from the FAQs of the. So I recommend you take a look at the FAQs in the Cal OSHA ATS. I just don't know the answer off the top of my head. Sorry about that.
No problem.
Any other questions? All right, seeing none, I want to thank you all for joining us this afternoon, and I hope that you each took something away from today's seminar. These seminars are extremely helpful in today's ever-changing world, and I am thankful that we can partner with the City of Corona to help put them on, as well as have great speakers on like Usama himself. So thank you everyone for joining, and have a great rest of your day.
Thank you.